Welcome back to the Exit Planning Series. Today's episode is all about keeping it clean, maintaining legal and ethical selling. Planning your business exit or succession is not just a final step, but a strategic move along long-term success. Simply put, it's good business. I'm Sean Sebold, President and Founder of Sebold Capital Management. Welcome to the series. So let's get to it. Keeping it legal, this is Chapter 4 of our Exit Planning and Video series. Okay, so in here, we are going to talk about lists. Super important. Non-disclosure agreements, we'll talk about those. Letters of intent. Due diligence. What's the deal structure? Representations and warranties, also known as reps and warranties. And the definitive purchase agreement. So all of these are important lists with regards to the exit planning process. NDAs, as they are referred, non-disclosure agreements. It is the first step in selling a business. So what does an NDA do? It says this is what you can disclose, this is what you can't disclose. So lots of things and lots of ways that this can be designed and in fact presented. Do you want the market to know you're going to be selling? Do you want the market not to know you're going to be selling? Now, that being said, once you give away your data, even if you have an NDA, that data is probably going to get out in the marketplace. It's very rare that that can be kept quiet. So just be very careful with the whole NDAs. Length of disclosure, enforcement, and dispute resolution. So in that, it's going to say if you disclose, therefore, we will be able to enforce. Again, there's going to be time frames in it. Each NDA is a little bit different depending on what the deal structure looks like. Failure allows competitors to leach, customers to leave. So again, you don't want information out that you don't want to get out. So this also will go into deal process that we'll talk about a little later in our video series. Letter of intent, what's that? It's the first formal offer of purchase. I intend to buy this. If you're in the real estate business, it would be the first offer. So you're not done until you get through a lot of other things. So yes, it begins the negotiation after the buyer receives all the information. So that, of course, is full of the process here. Okay, it's non-binding in terms of price and terms. So lots of times you'll see a letter of intent. It'll go out, oh, we're going to buy your company for $50 million. Does that mean you're going to get 50 million? No, we're a long way off of getting there. So this is just again, a prelim, a letter of intent. Okay, LOI only signed after negotiation. So after the negotiated, you get to that level, then you really start the work. Now you get the buyers get access to all the sensitive information, the financials, things internally that they want to take a look at in their next process, which is due diligence. Okay, in the due diligence, there's 4 steps that we need to focus on here. They are financials. Are the numbers accurate and sustainable? Legal, are there any legal issues, licenses, regulation, Department of Labor's 401k all up to speeds or cash balance plan, all those things. Tax, are there any old tax liabilities associated with it? So this is things that buyers have to dig into. And then operational, is everything running the way it should? Did you have any key people leave? Are key customers leaving? All those things are what buyers going to want to know. So good due diligence makes the deal smoother and an easier deal to make sure there's nothing out of whack that somebody wouldn't expect after a letter of intent. Deal structure. So you can get really creative with deal structure. When payments are, but there's 3 traditional models that you can kind of think about here. First is a M&A deal, mergers and acquisitions. So what happens there is you get the buyer to form an entity, and then that company is going to go into it. It's pretty common in this particular arena. The second is going to be the stock purchase. So the stock purchase is going to be someone is just coming out and buying the stock from you. So a lot of times that can be a C Corp. Then they're buying the stock and they're buying the liabilities associated with that. So not as common. And then the last, of course, is an asset purchase. So an asset means they're buying the assets of the company. One of those very common misnomers, they're going to buy the name of the company. They're not buying the stock, but they buy the name of the company, the assets of the company. And then, of course, there will be some legal considerations in terms of name changes and things like that. So those are the three structures. Then you've got reps and warranties. So what are reps and warranties? So this is a really big deal. All the guarantees that the buyer may require. So in the negotiation phase, when you're talking about, yeah, this is good stuff. Yeah, this is good stuff. This is where the buyer gets to find that out. Are all the assets in good condition? They're going to find that out. Are there any taxes? They're going to find that out. Are the financial statements accurate and reliable? Are there any undisclosed liabilities? Perhaps somebody served you with the lawsuit 4 weeks before the deal was closing. So that will then have to be disclosed. That's an issue. Excuse me. Inventory, is it good and good working order? You valued on the books, can we actually sell it? And all the useful information is in fact disclosed. Now, on the seller side, you of course want to know, do they have enough funds? Are they making a deal that they can't afford? So that's clearly it. And do they have a legal ability to purchase it? So if there's antitrust, if there's licensing requirements, all those kind of things. And that's pretty much it from the seller. So that's the reps and warranty side. Again, that's a pretty important spot. Now, after this, you get to the definitive purchase agreement. So that supersedes all the letters of intent. That supersedes everything and says, that's the deal we're going with. Okay, it finalizes the terms, closing date, working capital. If there's working capital that's going to be adjusted with regards to the close, if there's distributions that are going to be made. The last deal we had, a client had to get rid of their company car because the new purchaser didn't want their company car, so they had to distribute that in form of a stockholder distribution. So all these kind of things are at the end in terms of purchase agreement. This sets the reps and warranties in stone. So this is the last deal. And then regulatory actions may occur before anything's complete at the larger level if there's anything that happens in that space. So those are the big issues in this space. As we go forward, stay tuned for Chapter 5. We're going to talk about in our exit planning series, 1 + 1 = 3. We always want that. We want to make sure that we're optimizing synergy. Synergy, one of the most overused words in the M&A space, but there is a way that you can create value doing it. So stay tuned for our next video, and we'll look forward to seeing you then. Bye-bye.